Hi, good morning, good afternoon. Welcome to Estate Planning Very Basics for One, the importance of estate planning for singles and solo agers. My name is Sarah Kurth. I am founder of Life, Death, and Paperwork, where our goal is to normalize estate and end-of-life planning conversations, especially for singles, unmarried couples, and those surrounded by chosen family. Our agenda for today, first I have a few disclaimers, a few thoughts to consider as we begin. I want to help you understand your situation as a single or solo ager. Then I'll go through a few very basic legal concepts and what it looks like if you don't make an estate plan and why you probably won't like it. Then what it looks like if you do make a plan. And finally, I will help you take action by discussing a few next steps. Before we begin, I have to give the standard legal disclaimer. This presentation is for general education purposes only. It is not intended and should not be considered legal advice. Laws and rules vary significantly based on location, and what is appropriate for you varies significantly based on your circumstances and your goals. Contact an attorney or a medical or financial professional for advice specific to your situation. Considering the eventuality of your death and estate planning can be emotional topics. It can unearth lots of emotions and memories. So here are a few thoughts to consider and questions to ask yourself before we start. Consider these questions and journal about them if you're so inclined. First of all, why did you take this workshop? What has gotten you thinking about estate planning in the first place? Next, have you made any end-of-life or estate planning plans for yourself? Where are you in this process? Next, what have your experiences been of others' estate planning or lack thereof? I find that the majority of people who come to me looking for information on estate planning do so after somebody close to them dies without doing any planning. The resulting chaos has made it clear to them that they do not want to leave that kind of mess behind for their people. And finally, what words or concepts come up with you when you think about end-of-life or estate planning? Understanding your situation as a single or solo ager. More people than ever are aging without a spouse, a partner, and without kids. These solo agers have a unique set of concerns when it comes to estate planning. Solo agers don't have an obvious chain of command when it comes to decision making in the same way that legally married couples do. So it's important you consider and understand your situation and plan accordingly. If you don't do any paperwork, state law will determine who will manage your estate and who will get your stuff. Laws vary, but are always based on some version of figuring out your nearest blood relative. How well you knew them, how much you liked them, or how much you agreed with them doesn't matter. By default, friends, unmarried partners, and chosen families will not have a say in your care and will not have a role in your estate after you die. The default rules aren't what most people would expect them to be and aren't what most people would choose for themselves. I don't know many single people who would choose for their entire estate to go to a third cousin or a second cousin twice removed, not their best friends. But if you don't do any planning, that situation might just happen. A few very basic legal concepts before we begin. I do not plan on giving you a Law School 101 primer here, but understanding a few basic concepts will help you understand the scenarios that we run through a little bit later. Estate planning can get very complex very fast. I intentionally kept this presentation very high level and straightforward. I'll use plain English, but I'll occasionally mention the legal terms just so you hear them and know what to expect, and don't freak out if you hear them in the wild. In an ideal world, the people who love you the most and who are the most involved in your life would make choices for you and get your stuff, but this isn't the case. End of life and after a death, you are dealing with two institutions that are very old-fashioned and very red tapey: courts and medicine. Courts and hospitals want cut and dried relationships of blood or marriage, or they want paperwork. They do not want to have to quantify friendship or relationships. One very basic legal concept that is vital in estate planning is determining who will be involved. When dealing with medical, legal, or other official questions, we need to consider who can act, what can they do, and according to what authority, what document or what rule is allowing that person to take the action that they want to take. Another concept that's important to understand about estate planning is knowing the difference between you and your stuff. Who can make decisions for you as a person may or may not be the same person who can make decisions about your stuff. Your person includes the medical choices that are made for you while you are alive and what happens to your body after death. For example, if your organs are donated or if you're buried or cremated. Your stuff is your stuff while you're alive: your bank accounts, your clothes, your car, and everything else you own. After you die, your stuff becomes your estate. Note that while the word estate may conjure up visions of mansions and jewels, estate is just the fancy legal term for your stuff after you die. Everyone will have an estate. I found the best way to convince people to do some estate planning is to let them know what will happen if they don't do any planning. The specific rules vary by state, but these are the general defaults. If you don't do any paperwork, chances are in your state it will look something like this. If you don't do any paperwork and you are alive with capacity, so you're just a person walking around in the world, who can make decisions about your body and your medical care? You do. Who can make decisions about your money and your stuff? Again, you do. If you are alive but incapacitated, the example that is always used in law school is you are hit by a bus and you are in a coma, who will make decisions about your medical care? It is your spouse or your next of kin. And critically here, note that next of kin is your spouse if you're married or your nearest blood relative if you're not. Friends, unmarried partners, and chosen family are not considered next of kin. If you are incapacitated, who is in charge of your money and your stuff? No one. After you die, if you don't do any paperwork, who is in charge of making decisions about the disposition of your body? Again, it is your spouse or your next of kin. And who is in charge of your money and your stuff and your estate if you die and you don't do any paperwork? Again, it is your spouse or your next of kin. Again, your friends, unmarried partners, and chosen family will not be in charge of your estate and will not get your stuff if you don't do any planning and if you haven't done the paperwork. So what does all of this look like if you do the paperwork and you do some estate planning? Starting off in the same place, if you are alive and you have capacity, this looks very much the same. Who is in charge of your body and making decisions about your medical care? You are. Who is in charge of your money and your stuff if you are alive and with capacity? Again, you are. There is an option here of a power of attorney if you want somebody else to be able to sign on your accounts while you are alive and with capacity, but that's optional. If you are alive but incapacitated, this again is if you're hit by a bus and you're in a coma, who is in charge of making decisions about your medical care? It is your healthcare agent, or who is sometimes called your healthcare proxy. And this person is appointed via either an advanced care directive or a living will. The specific document varies by state. If you are alive but incapacitated, who is in charge of your money and your accounts and your stuff? You can appoint a power of attorney via a durable power of attorney form. After you die, if you've done the planning and you've done the paperwork, who makes decisions about the disposition of your body depends on where you live. In most states, decisions about the disposition of your body can be done by the healthcare agent or the healthcare proxy. This is the person who is appointed in either an advanced care directive or a living will. But in some states, your healthcare agent's duties end at your death, and in those states, you need to specifically appoint someone else to make decisions about the disposition of your body. What this form is and what it's called varies by state. After you die, who is in charge of your money and your stuff and your estate? Your executor is the person who will manage your estate, and you appoint your executor in your will. Your will is also the document where you will list who you want to get what. There is also the option here to name beneficiaries on certain types of account. These accounts with named beneficiaries will be distributed directly to the beneficiary after your death via the terms of the account, and these funds will not have to go through probate or the court system. So that's a lot. I know that's a lot, and hopefully I've convinced you that some estate planning and paperwork is necessary. But what exactly does that mean? Here are a few places to start. For more information on any of these items, talk to an attorney, an accountant, or a financial planner, or access reputable DIY resources. One way to avoid estate complications is for assets never to become part of your estate. Many of your assets can be transferred to others at your death automatically and without the involvement of the probate court. Adding a named beneficiary to retirement or investment accounts, or adding a payable on death beneficiary to bank accounts will make transferring those assets easier after a death. So look into adding named beneficiaries or payable on death beneficiaries to accounts like investment accounts and bank accounts. Next, complete a living will, an appointment of healthcare agent, or an advanced care directive. What this form is called varies by state, and in some states it's two separate forms, and in some states it's one form with two parts. A living will lists what medical decisions you do or do not want made in case of incapacitation. The appointment of healthcare agent or healthcare proxy is the document where you appoint the person you want to make medical choices on your behalf when you can't make those decisions for yourself. In some states, like where I am in California, an advanced care directive is a single document that contains both a living will and an appointment of healthcare agent in one single form. A good place to start here is with your health insurance provider. Most have living will or advanced care directive forms that you can use. Next, write your will. A will names your executor, the person who will be in charge of managing your stuff after you die, and lists who you want to get your stuff. Since your friends aren't automatically entitled to anything in your estate, a will ensures that your stuff will be managed and distributed to the people you want, even if you're not married to them or related to them. Next, consider a durable power of attorney if you want someone else to be able to deal with your financial accounts, pay your bills, or deal with other business affairs if you are alive but incapacitated. Make sure that the power of attorney is durable if you want it to remain in place if you are incapacitated. In most states, your healthcare agent or your healthcare proxy's rights that we just talked about in a living will or an advanced care directive includes the right to decide what happens to your body after you die. For example, if your organs will be donated, if you're going to be buried or cremated. However, in some states, body disposition is not included in those healthcare agents' rights. In those states, a separate release or a separate waiver is required to ensure that your preferred person is making those decisions for you. And just to make it extra confusing, what this form is called varies by state. Finally, document your stuff. After you die, all of your accounts will have to be closed and all of your stuff will have to be located and distributed. And that is a very difficult task for your people at a very emotional time. Documenting important information and accounts will make that process a little bit easier. Document information like where your accounts are, where your important documents are, important digital accounts and passwords, for example, email and online banking usernames and passwords. This presentation is really focused on the legal side of solo aging, but there are also significant practical and social issues that arise when you are a solo ager. For example, who will help you manage medical care or transportation? How will you minimize the potential for loneliness and isolation? But those issues are really beyond the scope of what we're talking about here. I just want to acknowledge those other issues that solo agers will have to manage as they age and as they plan their estate. So if you've decided that you want to start documenting your stuff, but you're not sure where to start, I have a list of items to document attached below as a PDF. If you want even more guidance on what you should document, I have a full checklist available for sale on my website. So that's a lot. I just threw a lot of information at you. If you remember nothing else from everything that I just talked about, remember that if you do not do any paperwork, your friends, your chosen family, or an unmarried partner will not be able to make medical decisions on your behalf if you are incapacitated, and they will not be in charge of your estate, and they will not get anything from your estate by default. So if you want your friends to be involved in any of those matters, be sure to do the paperwork. The document that I always recommend people start with is a living will or an advanced care directive. That document will ensure that the people you want making medical decisions on your behalf will be able to do so. And it will also document what medical choices you do or do not want made to help that person and to help your medical team. So start with that document, and from there, just take it one step and one document at a time. Thank you.